where legal experts analyze real cases.
Bye-bye. Thank you.
Did you still need Mr. Nick?
Yes, because we're trying to get his attorney back so we can get a date to recall that he's not eligible for Veterans Treatment Court. All right, Melissa Paez. Hello.
Hello.
All right, are there applications in these cases?
There are, Your Honor.
Court is calling 2025 CR 008396 and 2025 CR 014167, State versus Melissa Renee Paez. Can I have parties announced for the record?
Trey Maurer for defendant.
All right, and are you Ms. Paez?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. In each cause number, Ms. Paez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it? In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictments as presented in cause number ending in 9-6?
No, Your Honor, state moves to waive the enhancement allegation as well as count 2 and proceed solely on count 1.
Any objection?
No objections.
And are you proceeding on the indictment as presented in 6-7?
No, Your Honor, state also moves to waive the enhancement allegation in that clause.
Any objection?
No objections.
All right, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In cause number in 9-6, you're charged with fraudulent possession or use of credit card or debit card, 10 to 50 items as a second-degree felony, range of punishment. I'm sorry, you're only proceeding on one count, correct?
Correct.
Okay, it's just the way it's printed out. We're good though. All right, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. In the cause number ending in 6-7, you're charged with false statement to obtain property or credit, $30,000 to $150,000 as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call him the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Paez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or reentry. Did you understand?
Yes, Your
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, the state is waiving the enhancement. And in cause number ending in the cause number ending in 9-6, the state is proceeding on count 1. And in each of the cause numbers, the state is asking that your punishment be assessed at 10 years in the prison. There's a $1,200 fine. State is opposed to your application. They're asking that the causes run concurrently. They're taking in consideration 2025 CR 014168, 2025 CR 015020, and 2025 CR 015019. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? And each cause number, did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There were not, Your Honor.
And the cause number ending in 67 outside the agreement, there's to be no contact with Mission Mitsubishi at 9800 San Pedro, and there's to be no contact. Did you understand those were recommendations from the state, and the court does not have to follow that recommendation? Then in cause number 2025 CR 008396 to count one, how do you plead?
Guilty.
And in cause number 2025 CR 014167, how do you plead?
Guilty.
State, in each of those cause numbers, do you have any evidence to support the plea?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments in both causes.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, the state is opposed to your application. If you would like a PSI and a TAP evaluation, it'll be 8 to 12 weeks. If you would like it brought back sooner, I will listen to whatever witnesses or evidence that's submitted to me and make a decision.
Your Honor, after speaking with my client, we have a request if the court would consider signing the dismissals on the 3 cases that were taken into consideration in light of her plea of guilty and plea onto these 2 cases. If those 3 cases are closed out, and if the court would additionally consider reducing her bond slightly on the 2 that she has pled on, so she could take those full 8 to 12 weeks, organize her witnesses and people that she would like to be here on her behalf, and make sure that she has everything lined up for whatever the court does decide at that point. I believe that's what we are requesting, Your Honor, if the court would consider dismissing those 3 and possibly just slightly reducing the bonds on the 2 that she's pled on so she can organize everything and take the full time for the PSI.
All right, so with regards to bond reductions, you'll have to file a motion and then I'll hear it so that the state can be prepared.
Okay.
And if the state is waiving notice, just whenever you all get together, the court will do that. Now, with regards to the dismissals, any objections to the court signing the dismissals now, or?
Object, Your Honor, because that is something that ensures or will be dealt with at the resolution depending on what this court does.
And maybe I should have discussed this with you beforehand. If I may say, Your Honor, I've understood previously that if someone enters a plea and then does not return, that that plea can be, the court can say we're not going to accept the plea and that the full range is open. I believe that on its own will be sufficient to guarantee that she'll be here, and she'll accept whatever the court decides at that point.
All right, so this is what I can tell you all. This is new to me. With regards to the court signing the dismissals, the signing of dismissals to the court appears to be a part of your plea bargain agreement. And until the plea bargain agreement is accepted by the court, which it hasn't been accepted, right? The only thing that I'm doing is memorializing for the record that this is your plea bargain agreement. I have not accepted it yet. However, again, it's novel to me. If somebody brings me some case law that says that the court can make a decision with its own discretion to dismiss cases if a plea bargain agreement has been entered to but not accepted by the court, I'll consider it. But my understanding of the law is that unless the state says they're in agreement to these cases being dismissed now, they're really not to be dismissed now, because your plea bargain agreement, I haven't even accepted it yet and entered a sentence. I've just accepted the contract that you want to enter into. Do you understand? All right. So, but again, if somebody brings me case law that says something differently, I'll review it. I never said I know everything.
We take a quick step back just so I can discuss with my client very briefly, Your Honor.
Sure. And then let me know if you all want the 12 weeks or not, 8 to
Okay.
12 weeks or not.
Thank you, Judge.
Sure. All right, Norma. The attorney hasn't come back, but I know he said that he did not want the PSI on Mr. Smith. When do you want that brought back?
He said he's on his way back.
Ah, okay. And usually this is what I've discovered. When we have a docket that is not as full, we still end up being here for a long time. But I like to make sure that I hear everything. And this is what I tell people about judges. Well, about me. I don't claim to know everything. I don't know every law under the sun. But if somebody brings me some law that says, Judge, you're incorrect, I'll listen to it and change it. Or if it's something that's novel, like that is novel, that's the first time that's been brought. But if he brings me case law and says, oh, no, Judge, it's within your discretion, then I'll hear it. Yes.
Your Honor, my client has decided to do not the full PSI. Will come back sooner rather than later.
All right, so let's go. We're back on the record. If you'll come forward. All right, so are you asking that the PSI be waived? All right. And then with regards to TAP evaluation, are you asking that that be waived as well?
Is it going to be the same wait time, Your Honor?
Vashon, how long is TAP just for a TAP evaluation? TAP evaluation is 4 weeks.
We'll do the TAP evaluation, Your Honor.
All right, so there is a request for a TAP evaluation. It's in both cause numbers. It's 2025 CR 014167 and 2025 CR 008396. All right, Ms. Ferguson, what date? Yes, and Ms. Abrams, if they can expedite that and maybe get it to us sooner than 4 weeks, we'll try.
I can do February 25th. Oh, I'm sorry, the 26th, Judge.
February 26th. And if for some reason, if they're able to do it sooner, they'll let your attorney know.
Yeah.
All right, you're welcome. Is there anything else?
Nothing to prevent.
All right, with that, we'll close the record.
Thank you, Your Honor.
And with regards to that, is there any restitution that's being alleged? Okay, all right, thank you. Okay, well, I will see you all on Thursday. We're just waiting. State if you can remain because we're just 2025 CR 014998, State versus Vincent Munoz. Could I have parties announced for the record for the state?
David A. Garcia, attorney for Vincent Munoz State.
And are you Mr. Munoz?
Yes.
Counsel, in that cause number, have you received all discovery? Did you review it with your client?
I have and we have.
Court will find that the state is in compliance with discovery. Mr. Munoz, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? Any
No
objection?
objection.
Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right, the state is proceeding on the lesser included offense of criminal trespass as a Class B misdemeanor. The range of punishment is up to 180 days in the Bexar County Jail and up to $2,000 fine. Did you understand?
Yes, sir.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, and the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Did you understand if you're not a U.S. citizen, by entering this plea, you may be deported, denied naturalization, and re-entry?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of criminal trespass. Punishment is to be assessed at 114 days in the Bexar County Jail. There's an $800 fine and no applications. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
We reviewed State's one and all attachments, Your Honor. We have no objections.
All right. Mr. Munoz, did you review the document entitled Waiver and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. agreement. The court will find you guilty of the lesser included offense of criminal trespass. Court will sentence you to 114 days in the Bear County Jail, give you credit for any time served. There's an $800 fine, time and money to run concurrently. With regards to sentencing,
No, Judge.
and I'm so sorry, and this will run concurrently with all right, 2024 CR 1361.
Yes.
All right, on that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? We're moving on to cause number 2024 CR 2024 CR 1361. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Vincent Ambrose Munoz who was placed on deferred adjudication in 2024 CR 1361 for the offense of abandoning a child criminal negligence on April 9, 2024 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violation or interest taxes members in their welfare ordinance office as directed by commissioner.
How do you plead to that? True or not true?
True. No, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility
Yes.
and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court would find violation of condition number 4 true. Is there a proposed agreement? All right, in defense, what are you requesting?
Judge, we went over so that my client would have an opportunity, one, to be reinstated, and if in the alternative, to see if you could be a little bit more lenient with the states. He faces 2 years state jail. Clearly, he made a lot of mistakes. Probation's recommending revocation. State's recommending revocation. He just pled to a burglary that was reduced down to a criminal mischief. He made a lot of bad choices. He was close to finishing one of his classes, and then the burglary arrest occurred. Doesn't excuse what happened. He made a bad mistake to go someplace with who's now the mother of his child, mother of his child to be. She's due in 4 months.
She's due on June.
In June. 5 months. He should.
What did she do when that criminal trespass occurred?
No, we found out she was pregnant when she was incarcerated.
Okay.
She got arrested with him on that at that instance. She was. Our understanding was the main aggressor at the door, but the state reduced her case to a criminal mischief, and they did so with my client. He understands he made that mistake. He should have never been there. They went there to get the clothing for Kimberly's children, not his child, correct? But nonetheless, it was a bad mistake to go. He understands that. That's why he took this plea. He understands he had been making a lot of mistakes on his probation. But while he's been sitting in jail, Judge, he's tried to turn his life around. You saw the certificate of completion for the child class, the fact that he's been going to meetings. He's really been trying to change things for himself, even though he understands he made a mistake, and it's a grievous mistake. He's throwing himself on the mercy of the court, hoping, one, you reinstate him. He's got a job waiting for him. He's got this baby coming in 5 months. And if not, he understands, but he's hoping aspect also a reason you didn't show up? Explain that to the judge.
A lot of money that I had saved up was going towards hotels, and I didn't really have nowhere to go, so that was mainly where my money was going at, and I didn't really have a car, so I would always use Uber to get food or something like that.
And you're not trying to tell the judge that you have an excuse for everything, correct?
No, I take full accountability for my.
So you understand you did very poorly on this probation, but you're trying to explain why. It was, a lot of it was financial. And so you would show up to meet with your probation officer, they would tell you to show up for a urinalysis test, and you told them you didn't have the money, correct?
Yeah.
Because it costs every time you show up to give a urine test.
Yeah.
And so that's, and you pled true to not showing up because you didn't, right?
Yeah.
So even though you messed up on your probation, you were trying, correct?
Yeah.
And you almost finished that parenting class through probation, didn't you?
Yes, I was going faster than.
And then you got arrested because of another bad decision, right?
Yes, sir.
Yeah, but while in jail, you did complete the parenting class.
Yes, sir. And then I started my 3 classes.
If the judge grants you this opportunity to stay on probation, can you promise her, in spite of financial reasons, you'll make every
told me, it's you're relying on somebody else. Kimberly has money that she's been saving up since she's been in custody. Somebody else has money, your grandmother, they've been saving up money. And if neither one of them give you that money, we're gonna be right back here.
Well, I have that job waiting for me, so I'm willing to work with that. My mom told me they paid from 17, 18 an hour, and I'd be working 3 days a week, so I'd save up all my checks and just pay what I need to pay off myself, take care of my responsibilities.
Any objection to the court reviewing the court summary?
No, Judge.
Any objection? Have you read the court summary?
Yes.
All right, after reading the court summary, probation is basically saying you were never compliant. They said that there was a previous motion to revoke, and this was with a different judge. They say following a motion to revoke filed on October 31st, 2024 for a new offensive assault, his conditions were amended on January 9th to require weekly reporting indefinitely and residency with his mother. It says, despite these directives, the probationer refused to reside with his mother, citing conflicts, and instead stayed temporarily in a hotel before moving in with his grandmother, failing to provide proof of residence. He has remained unemployed, completed only an aggressive driving course on May 20th, 2025, and otherwise made no progress or required parenting or other classes. He has paid only $38 towards his fees, leaving a delinquency of $1,412. And see, I understand when people can't pay money, but from 2024 to only have paid $38 towards your fees, that's sort of not really trying. And they say his reporting has been inconsistent with frequent failures to appear and intermittent walk-ins, and field visits were often unsuccessful due to his absence. A manager hearing on August 22nd, 2025 documented his continued noncompliance and failure to pay fees, during which he was encouraged to obtain employment. Despite these interventions, he remains noncompliant. Yeah, I don't think probation is for you. I'm going to grant the motion. I'm going to find you guilty, revoke. This will run concurrent with 2025 CR 014998. The court will sentence you to 20 months in the state jail facility, give you credit for any time served. And I'll ask for the therapeutic community. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign?
Yes, Your Honor.
All right, you have a limited right to appeal. The right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And I want you to know your attorney did do a great job, and I did listen to everything and internalize everything. But sometimes, you know, you're just not doing well on probation, and there's nothing I can do. Okay?
Yes, ma'am.
All right. Good luck to you. Okay?
Thank you.
All right. On moot. Yes. Does she have? She has someone at the microphone. Oh, excuse me. No, that's not what it is. Could you speak with Ms.
Megan?
Galloway?
I
on
did.
that? Yes.
I did. And I told her that I would speak to him to see what after I explained fully to him what the potential was.
Okay.
He decided that he would like to try and get probation.
Mhm.
So I went ahead and filed a motion for new trial. I had given her a copy of that. I assume she's just going to oppose it. So whenever the court wants to set it, that's her.
Oh, just said it. I don't know. She may not oppose it. I'll need to see his criminal history. I know he said he only had theft cases. I just
Right.
need to see.
I told him that you had not seen the full
Yes.
spectrum yet and that might affect the outcome, but he wanted to try.
Okay. And then what I can tell you is if check, see if 3 weeks was